the first part of the holding is that the Second Amendment protects the right to carry arms for self-defense outside the home. And that's something that lower courts had mostly accepted, even though, Heller and McDonald, the earlier cases, dealt with bans on guns in the home that, extended into the home, and you had to keep your gun in an unoperational state, as with the DC law in Heller. And so, this is, as I said, it's something that was sort of generally accepted. It's something that the parties in this case agreed on, that the Second Amendment extended outside the home. And so that's the first part of the holding. And the second part is the more notable, the part that will have tremendous consequences for Second Amendment cases going forward, and that is that the court announced a new history-focused approach to deciding, after you make that initial determination that the conduct is protected by the Second Amendment, you then, the government is required to come forward with evidence that the regulation at issue is supported by the nation's historical tradition of gun regulation, right? So you have to find analogous regulations in history to support a regulation. That's different than the test that had the Court of Appeals had coalesced around this two-step. It's called a two-step test. We can get into that. That's a little bit confusing to me because it's sort of three steps, and Bruen itself seems like two steps. But anyway, the court rejects this two-step framework and says that you don't use means and scrutiny in a Second Amendment context. You look to whether the regulation is consistent with history.
Yes, I believe Thomas, in the majority opinion, said that the two-step test was one step too many, effectively wiping out this decade-long trend of using this two-step or three. Maybe three-step would be more appropriate, but determining whether or not the Second Amendment is implicated, and then using effectively a balancing test of what the judges would often call intermediate scrutiny, what critics would usually derisively refer to as rational basis, which is the lowest level of the balancing tests, in order to judge these cases. But still, the higher court did not find that to be an appropriate approach for Second Amendment litigation. And now we have a whole new approach, something fairly similar to what gun rights activists have been wanting and advocating for ever since Justice Kavanaugh sort of came up with it, or coined the approach in dissent that he wrote in another Heller case, right? I believe it was Heller 2.
That's right.
Which was about DC's assault weapons ban, where Kavanaugh was on the wrong side of a 2-1 opinion, but his dissent became very influential in gun rights circles as this what had been called text, history, tradition test. Now I guess Thomas wanted to shorten that down a bit, and it's just text and tradition. I guess the history is kind of implied with the tradition part, but then you also had a series of concurrences, which you actually wrote about over on Duke's Law Center website. Can you tell us a little bit about what you make of those concurrences from, because you had three of them, right? There was Kavanaugh joined by Roberts, then Alito had his own concurrence, and then Barrett had her own concurrence as well. And can you just give us your view on what do those concurrences say, and what do you think they mean, in the context of this full ruling?
Sure. So it's always a little bit tricky to try to figure out why a justice who, in this case we have actually 4 justices in total who joined Thomas's majority opinion, but also chose to write separately. I don't think that's unusual in a high-profile case like this. Justices simply want to sort of get their take out there, and there's certainly no restriction on them authoring a concurrence as well. But I think there are some interesting things to unpack about these concurrences. And the first is that, there's this paragraph in Heller, which gets, I think reproduced or at least quoted extensively in McDonald, that says, essentially, and I'm paraphrasing here, nothing in this holding casts doubt on certain longstanding gun regulations, right? So prohibitions on felon possession of guns, mentally ill, sensitive places. We can talk more about that because that's really an interesting one. But anyway, this paragraph, it got a lot of attention at oral argument in Bruen, and what we see in the opinion is that there's a page or two that talks about sensitive places, where Thomas says, we're not going to extensively analyze or provide a framework for sensitive places, but here's a few things that we think lower courts can consider. But the majority opinion does not reproduce that paragraph. So if you look at the concurrence by Chief Justice Roberts and Justice Kavanaugh, they actually cut and paste the paragraph from Heller and put it in their concurrence. I don't know why, but it's interesting to think about, whether that was a point of disagreement among the justices, right? Because you'd think that if Justice Thomas wasn't trying to cast any doubt on this paragraph in Heller and these type of prohibitions, that he would have been willing to put that verbatim into his majority opinion. That's not what happened. Well,
he does quote it at one point.
Yeah.
He doesn't reproduce the entire paragraph like you're mentioning there, and they do. And you're right, they do emphasize that in the Kavanaugh-Roberts concurrence. I mean, that the Kavanaugh-Roberts concurrence is kind of all about this is true, but doesn't mean we're, throwing away these other possible restrictions.
Right.
Shall issue permitting is perfectly fine as long as it's, you're actually doing it and not just using it as a fig leaf to not issue permits. But, so it certainly is, they're sort of re-emphasizing that this doesn't mean that all gun laws are now unconstitutional, which was kind of the point of the initial paragraph, right, in Heller.
Exactly.
Just to re-emphasize that this just applies to the thing we're talking about. Bruen goes a little further than Heller just because now they're giving a more, they're spelling out how lower courts should approach these cases, right? But it still doesn't, they're not striking down all kinds of different laws. They're just dealing with the gun carry law in New York, and then they're moving to the how to decide these Second Amendment cases going forward, right?
That's right. Yeah, and as I said, it can be perilous to try to determine why a justice decides to write a concurring opinion. But it's notable that's emphasized,
yeah.
And I think Alito similarly emphasizes the point that you mentioned about may issue versus shall issue. Right? He says nothing. We're not dealing with shall issue regimes here. Those are fine. Nothing we've said here should cast doubt on them. So, again, just like a theme that runs throughout those two concurrences. That at least as far as the holding that Bruen is limited to the type of permitting regime that New York had, which these other few states did as well.
And then Barrett looks at your analysis of Barrett's concurrence. I thought was really interesting because I thought a lot of the same things. But she brings up this point, which is important, about all right, well, if we're going to be using tradition, how this how states and the federal government have traditionally regulated guns, as a guide for whether or not a modern regulation is constitutional or not. Well, how do we actually make that determination? Where are we looking? Do we look at right after the ratification of the Constitution? Do we look at after the ratification of the 14th Amendment, because we're using that to incorporate the Second Amendment to the states? And she doesn't really answer, because she says it's kind of doesn't really matter in this particular case because the laws at those two periods were similar anyway. But she doesn't, like you said, she didn't really give an answer, right?
Right. And I think, I think you're right. It's a little bit odd in that she sort of raises these historical issues, but then says, I'm just writing to kind of put them out there. I guess she agrees. She does agree with Thomas that they weren't necessary to decide Bruen itself. But these are important issues, albeit I think a little bit technical, and this question of this sort of ongoing legal debate about, where do you look, when the Second Amendment or another provision in the Bill of Rights is incorporated against the states through the 14th Amendment, what history do you look to, right? you could either look to the time that that original language was ratified in the Bill of Rights in 1791, or you can look to the time that the 14th Amendment was passed in 1868. And I think no matter what you think of the court's historical analysis in Bruen, there are certainly going to be cases where the answers are different, and the answers depend on whether you look to 1791 or 1868.
Right. And so that's, down the line, she makes a good point about down the line. This is going to matter a lot, especially if this isn't limited to just the Second Amendment. It's going to matter a lot in Second Amendment cases, but Thomas talks about in the majority ruling that this kind of analysis isn't really limited to the Second Amendment. They use it in First Amendment cases as well, and so forth. So she raises an interesting question, but doesn't do much to give us a real answer on how. I guess it's just like we need to figure this out at some point, guys. Like, so we should probably give guidance on this.